This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviat. Tonight we're talking about grandpa and the law. We're talking about wills, trusts, estates, powers of attorney, things like that. Okay, it may sound a little dark, but it's a good idea to have the planning in place either for yourself or for your loved one. If something happened to you tomorrow, what would happen to the people that you're leaving behind? Do you have a will? Do you need one? Do your family members know where to find it? Do you know where you ought to have those kind of documents? What about powers of attorney? What do you need? Tonight's your night to call in and ask those questions. The 31 Law Call number, 256-536-0077. We'll also have some of your email questions, and you can send an email question on any legal topic any day of the week. You send it to lawcall@waaytv.com, and when we get to a show that's on point, we pull out some of those email questions, and we've got some of your email questions tonight. Getting us started tonight, Michael Timberlake is here from Timberlake & Leak. Good to have you here.
It's great to be here.
You've got somebody sitting beside you?
Yeah, we brought Will Pilot here to help answer questions about the grandpa and the law.
Yes.
That's right. Thank you all for having me.
Thank you for being here tonight. We're getting started. We always like to bring you a video. We pull something off of YouTube. This is your chance to make the law call. Okay, you think about important vehicles, sirens approaching, and you think, all right, I should be very careful because I might get a ticket or something, but you don't always think about these emergency vehicles and the accidents that you can get into if you're not paying attention, if you're paying attention to your phone, you're fiddling with your radio. Michael, when you see something like that, what do you think? As a personal injury attorney, what are you thinking when you see accidents taking place like this?
Well, I mean, the first thing you talk about is you think about is you say that, emergency vehicles, they have special rules that attach to operators of those vehicles. And if they're operating the sirens and they're operating their lights in a manner they're supposed to be to warn other people that they are in an emergency situation, then they have the right of way. Their drivers, preempt other traffic control devices or traffic control laws. So really in that situation, you're looking at it thinking, okay, these people have, your ambulance drivers, your, police officers, as long as they're operating their emergency equipment the way they're supposed to be doing it, then they're going to have preference over other drivers. So that's kind of the main thing that you take away from this situation.
And you see problems like this a lot of times because people are distracted, and there's some new laws around our area that you need to be aware of because they're cracking down.
Yeah, Thursday night, Huntsville City Council passed a law that it augments existing state law, and basically they passed a state law, a legislature last year that made texting while driving or holding a mobile cell controlled device, and they made that illegal. They made that against the law. So you can't, look at your phone while you're driving. You can't hold it in your hand while you're operating a motor vehicle. But the state made it a secondary offense, which means they could only cite you for violation of the rule if you were violating some kind of other rule. Huntsville City Council this week took it another step. It said this is a primary offense. So police officers will be able, in Huntsville and the city limits, will be able to pull people over for holding a cell phone in their hand while talking, while operating a moving vehicle. So it's a pretty significant thing.
And if you watch people at intersections, you see it all the time. They're going to be very busy if they take this seriously.
There were some issues about, whether they could enforce this, whether it was, going to be something that was just another pretense for officers to pull people over. But they put it through and they got it into law.
We are taking your calls and questions tonight about grandpa and the law. We're talking about estate planning kind of things. And we've got with us Will Pilot. He is an estate planning attorney, and we wanted to talk to him about all of these things. Calling your questions, the 31 Law Call number, 536-0077. Start us off with what kind of documents you feel like all of us should have.
Yeah, great question. And so I think for everyone, there's 4 documents that I really recommend having. That's last will and testament. So that's where you decide how you want to leave your property. That can be outright or in trust. Power of attorney, and so that is an authorization for someone else to act on your behalf. Name an agent and an alternate. I always do a healthcare power of attorney. I think they're useful from a practical standpoint, and so that's someone that can make healthcare decisions for you. Then lastly, an advance directive for healthcare, and so that's primarily for end-of-life decisions. You would name a healthcare proxy and an alternate on that as well.
So a will takes effect once you die,
That's right? That's right.
The other ones, when do they actually take effect?
Yeah, great question. So a power of attorney is usually effective at the moment that you sign it. Now you can have a springing power of attorney that's only effective upon your incapacity, but generally most of them are immediate.
Okay. And then the Advanced Healthcare Directive, when's that effective?
Yep, immediately as well. And Sharon, some people call that the living will. You'll hear it called that. Use that term sometimes, and so, but it's effective immediately as well.
That's like the end of life, what kind of care you want in the hospital.
Yeah, exactly. So it's kind of those, whether you want to be hooked up to life support or whether you want to have artificial food and hydration if you're terminally ill.
So you've got like a document that gives people directions on what you want. Who actually carries out those directions?
Yeah, that's a great question. So your agent carries out your power of attorney, and so that needs to be someone that you trust, because they're going to have access to your bank account. They're going to be able to sell real estate, and so make sure that you trust that person. The executor carries out the will, and so that's someone named within the will, and the healthcare proxies for the advance directive.
Oh.
We've got callers waiting. We've got Howie on the line with a question. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, hi. I just recently purchased a clerk's deed to someone who's interested in a house that's been left in a will, and the estate is still open. And I want to find out, do I need to race on down to the probate court to somehow file a claim against the estate with that deed? Do I need to present the deed? How would I go about making that claim?
Gotcha.
Yeah, it's a great question. Yeah. So I'd make sure, number one, that you consult a lawyer for it. But then secondly, you're going to want to make sure that that deed is recorded. I think I'm understanding that he received a clerk's deed, and so want to make sure that you record that deed. And then you're right, it could be end up being a claim against the estate. So you may end up needing some title work done to clarify that. You may need either an heirship affidavit to tie it together or some quitclaim deeds to tie that together. And then lastly, with some of the heirship property in the probating estates, we end up actually having to go to court for like a quiet title. And so it could be any number of those. It's hard to tell from just that little snippet, but yeah, certainly first just get it recorded.
Okay, where should people keep these documents that you're talking about? So the will, the powers of attorney, and the living will. Where do you put that stuff?
Yeah, keep it someplace safe. So if you put it in the vault at the bank, make sure that someone else has the key, or we have to get an order to drill the box. And so make sure someone's got the key. At the desk, just a safe place that the house is fine. Make sure that someone else knows where your important documents are. So they're not going to do a whole lot of good if no one else can find them.
Yeah.
Yeah, if you have a paper copy of a document, it's not the original, can that suffice in this situation?
It can, yes. And so, it's not going to stop banks from giving you a hard time about it. They may require a little additional paperwork, but a photocopy should be as valid. And then most lawyers now will scan and save all of your documents to their system and email it over to you as well. So try and make sure that you're getting that.
A lot of people assume that the will, as soon as you sign it, is going to get filed at the courthouse.
Or that your lawyer hangs on to it.
Or your lawyer's going to keep it safe for you. Okay, talk to us about that.
Yeah, so there's no mechanism for recording a will before death in Alabama. I think there's some states that have that. Alaska may be one, oddly, but Alabama does not. And so, so some lawyers will hang on to them for you, keep them in a file. Others won't, and so make sure you clarify that when you go to get it done.
Talk to us about. A lot of people want to do things online. There's so many things that you can do online now, and they'll think, I can spend $50 or I can spend more than that and go to a real lawyer to do it. And they assume they can do it themselves. Especially smart people think they can do this themselves. What's your advice on that?
Yeah, well, I guess I'd say number one, those kind of keep me in business on the estate litigation side too. And so
when they mess it up,
that's right.
Business.
Yeah. So we'll see lots of different, I'll say iterations, but lots of different ways that you can screw those up. And so just encourage you to be very careful with that. A will must be witnessed by two people. Sometimes we'll see where they're notarized but not witnessed. That's not valid under Alabama law, and there's no way to make it valid either.
Yeah, and we tell people a lot of times is, look, you can spend some money on the front end by getting your documents in place, getting it right. It's not a lot of money. It's not cost prohibitive to do it. But if you don't do that, then what you're doing is you're leaving the people that you're intending to leave things to in a lurch, and you may not be able to do what you want to do. So that can be a problem.
A lot of it depends on how things are titled too, right? I mean, you can make up a will or you can do something online, and you think you've left things a certain way, and if the items are titled differently than you expect, it's going to be a problem. Explain to me what the problem is.
Sharon, I see that every day, and it causes more frustrations for families than just about anything else. So what often happens is, mom or dad or grandpa or grandma makes a will and they want to leave everything equally to the kids, but maybe they put one of the sons or daughters' names on the account as a joint owner or as a POD or TOD. If you do that, that account's going to pass to them outright, regardless of what your will says. And so if it's your intent to split that amongst your children, then make sure that that you either add everyone's name on the account, or better yet, just leave them off and have them pay your bills using a power of attorney. Don't put them on the account.
Okay. They're telling us to take a break. We're going to take a break. Be right back, answering more of your questions about grandpa and the law. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're asking questions all about grandpa and the law. We've got with us Michael Timberlake from Timberlake and League, and we've got with us Will Pilot with the Pilot Estate Law, and he does these kind of cases. So that's everything from wills, powers of attorney,
probating estates,
probates, trust, and we've got callers waiting. Kim is on the line with a question from Huntsville. Hi, Kim. Thanks for calling. What's your question tonight?
Hi. Thank you for answering my call. I want to know the difference between a living trust and a will, and which one is the better route to take as far as my children. I don't know which. You hear about two different ones, which is better to leave in your children's name. Can you tell me which one is the best route to take?
Talk us through that.
This is kind of a good question, because a lot of people think, or a lot of people try to sell you a living trust or a living trust. This is what you need. Real thick, big document. It's a nightmare, I think. But tell us what the difference, and when would you recommend one or the other?
Yeah, it's a great question, Sharon. I think we were talking about it before we came on the air. But I try and avoid I call them California or New York trusts that are a couple inches thick. And so the revocable living trust is useful in that it avoids probate. And so in order to do that, all of your assets need to be titled in the name of the trust. And then when that's done, there's no probate assets. So your will is only going to distribute probate assets. And so with the revocable trust, you don't get any liability protection if it's a revocable living trust. You also don't get any tax benefit, but you do avoid probate. And what that means for your heirs and for your family is that they can get their share of their estate, of your estate, quicker, so they don't have to wait the 6-month probate period. That's the primary reason. There's some others, privacy as well. If there's out-of-state property, transfer that to the trust. We can avoid ancillary probates. So there's a few flags, but the main is avoiding the 6-month probate period.
Everybody's so afraid of probate, right? Avoid probate. Is probate such a daunting thing or an expensive thing?
It is kind of what you make it. And so if everyone's in agreement, it's going to be a lot smoother process. There are some people that have a terrible experience, but Alabama's law is not as punishing as California or New York or some other states. And so the general things to keep in mind is that it's going to be a 6-month process and that the state is subject to creditor claims. So those are things to bear in mind.
Gotcha.
Yeah, and there's a lot of ways you can do some basic estate planning, especially in a small estate, and really kind of establish everything you need to do, and then go through probate. You can list your assets in a way with right of survivorship, right?
That's right.
So that just goes to automatically to somebody. So you can pass a lot of your estate assets along without having to go through probate. But probate in itself, it's not really that big of a process, right?
It's not that terrible process as it sometimes is made out to be.
Right, and it's not expensive typically for a regular estate.
Yeah. I mean, the lawyers, I guess, are going to get it on the front end or the back end, and so again, compared to other states, it's really not. It's a doable process.
Right.
When you're talking about rights of survivorship, the way most people hear that is married people own a house together, and it's usually rights of survivorship. So the instant I pass away, my spouse owns it completely, totally.
Right.
And it doesn't go through probate. That's what you're talking about.
I guess.
Yeah, that's exactly right. And so if you have assets like a bank account that are jointly titled, then those assets are going to, upon the death of the first owner, they're going to go all entirely to the remaining co-owner.
Yeah,
no probate.
No probate. It just goes automatically. And it doesn't have to be a spouse. It can be your child. It can be somebody else, and anybody in that situation.
Gotcha. How does the deaths and the estate planning kind of things, when somebody dies with a personal injury case, so if there's a terrible car accident, somebody passes away, who's got the right to bring a lawsuit, and what happens with those funds?
Well, in Alabama law, if it's an adult, if it's a minor, then the custodial parent has a right to bring the child. And if the folks are still married, and either the mother or the father, if they're divorced, the person with custody has a right to bring the lawsuit. However, other than that, you're looking at a situation where the personal representative of the estate is the one that has the right to bring the wrongful death suit and to collect the wrongful death proceeds. You know, how's a personal representative typically established?
That's a great question. And so typically that process looks like they go to meet with the lawyer, and then the lawyer prepares a petition for them to sign. They file that with the original death certificate in the probate court. Then the court issues what's called letters of administration.
Right. Now, is that somebody that's appointed in the will, or can it just be anybody?
Yeah, that's the good question. So if there is a will, then that person, the named executor, would have priority. If someone dies without a will, then that's someone that really gets to the courthouse first. There are some priorities, but it's important to get that done quickly so that you're in control of the case.
Yeah, I mean that's a lot of situation we deal with is establishing, in a wrongful death case, who's going to serve as the personal representative, who's going to be in the position to talk with us, to handle the litigation, to work through it.
And then what happens with the proceeds if you win the lawsuit? That money, does it go according to the will, or how does that money go out?
Yeah, I mean, it's a great question, because you would think that, okay, if somebody dies in a wrongful death lawsuit and they have a will, then the proceeds of that would go to the beneficiaries of their will, the people that they would identify. But that's not actually the case in Alabama.
It's not. Yeah. So Alabama law is fairly unique with wrongful death. It's going to pass just according to the statute of intestacy, which is your heirs at law, and so that's going to go even if you intended to disinherit one or more of your children, it's still going to pass to your heirs at law.
Yeah, and I've had situations. Part of it goes to your surviving spouse.
That's right.
And I've had situations where people have been. They've been estranged for years and they just never got divorced.
Oh.
But it's still, under Alabama law, the surviving spouse steps in and takes a large portion of the proceeds. And they keep it.
They keep it.
Yeah.
Okay. Let's talk a little bit about testamentary capacity. When somebody's wanting to get a will done, or the family's getting worried about grandpa, and they want them to come do a will, talk about how sharp does that person need to be in order to do a will, and the will and those documents be valid?
Sharon, I'll say first that it's great to get it done sooner rather than later. Get it done when you're younger rather than older. If we have to come see you in the hospital, then that's a tougher situation. And so we prefer to meet with you when you're clear-headed and know what you want. That said, Alabama law recognizes that you should be able to make a will until late in life. And so the capacity to make a will is actually lower than the ordinary capacity to contract. So what that means is that in order to make a will, you have to know what's called the natural objects of your bounty. So your kids, your family. A little bit, you have to know a general overview of the property that you own and have a testamentary intent to dispose of that property. So those are the three things, and it's lower than the ordinary standard to make a contract.
When you say it's lower than the ordinary standard, does that mean that you can be, for lack of a better term, out of your mind at one point and then be lucid again and then create a valid will?
That's where the witnesses are so important. So yes, the Supreme Court, Alabama Supreme Court said if you have a lucid moment, then that can be a window to make a will. But that again is where lawyers' advice can come into play, and then also just making sure that that witness testimony really could become important.
We always invite you to send in email questions, and we got this email question from Chris. Chris wrote in, "My dad is getting unable to take care of himself. Are there different kinds of power of attorney depending on whether I need to make medical decisions or financial decisions? I'm not sure where to start." What should you tell them with that?
Yeah, I mean that's kind of what we talked about right off the front. There's power of attorney that can start when someone's incapacitated. There's a power of attorney that can start immediately. What's the benefits and how do they come into play?
Yep, and another great question, something that we see every day. And so there's the general durable power of attorney for finance, and so that's an authorization for someone else to sell your real estate, to access your bank accounts, to pay your bills. There's also a healthcare power of attorney, and that's someone that can make medical decisions for you. They can sign you into rehabilitation. They can consent to surgery, things like that. And so, as Michael said, that power of attorney that can be what's called springing, and so it is only effective upon your disability. The problem we see with that from a practical standpoint is that it can be tough to get two doctors to agree how most of them are set up. It can be tough to get two people to agree that you're incapacitated.
Yeah.
Right, and so that's when you need it. Is when you don't have the ability to make your own decisions. Right. You need your power of attorney to do it for you, and that you don't have the ability to do that, then it's not any good.
Yeah, that's exactly right. And if you don't trust them when you have capacity, you're only going to trust them. That's why I say, for most folks, just go ahead and get the general durable power of attorney that's effective immediately.
Right.
We've got, is it Dee or is it Dean on the line? Thanks for calling. Hi, Dee. Thanks for calling. What's your question tonight?
Yes, I wanted to know. I had paid my attorney first $400 on a will, and then he wanted $2,600 to get a good deed for a house I have. And the guy that claims he still owns it, my attorney wanted me to give him $4,000 for the sheriff to go out there and give him papers on it. Now, I don't think it should be that much money.
It may be time, if you're confused and you don't like the price, it might be time to go see a different lawyer, right?
Yeah,
you can always get a different lawyer, fire whoever you had if you don't like it.
Absolutely, and lawyers will, in a situation like this, then they will give you a retainer cost, right? And sometimes they don't, or they can charge you one way or another. They can either bill you after the work is done, but a lot of lawyers will work on a retainer, and they won't charge you until the work is done. They can't take the money out of their trust account until the work is done, but they'll document what they do for you, right?
They should, sure. And all of those fees should be fair and reasonable, so it's hard to see what all will be involved. If it's heirship property, there'll be more involved. But yeah, I'd always just check with them and see the scope of the work, and maybe ask about a flat fee.
Right. And when you're doing deed research, sometimes you don't know what it's going to be. If you're
That's
trying
right.
to quiet title to a piece of property, you've got to look and search back, a long way. And sometimes if the title's not clear, there's a lot of work that has to be done.
Yep, that happened to me just last week. So
they're telling us take a break. We'll be right back. If you didn't get your questions answered tonight, here's how to get in touch with Will Pilot. He is with Pilot Estate Law in Huntsville, 256-529-4747. Also check out pilotestatelaw.com. Here's how to get in touch with Michael Timberlake with Timberlake & League. They are personal injury attorneys, so everything from car accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon's our resident family law expert. She practices family law here in Huntsville. She does child custody, divorce, that type of thing. 256-539-7337 or SharonFamilyLaw.com.
Thank you very much.
You're welcome.
Thanks for all your calls and questions. We'll see you next week.